Welcome everyone to this event. Can the ERA Act help reach 100% open access? We believe this is a really good opportunity for us all to mobilize and influence and support our research offices in our organizations who will be submitting to the ERA Act consultation in January next year. So this is to help you prepare for that. My name is Vanessa Proudman. I'm the director of SPARC Europe, and I'd like to welcome you today. I think you've noticed we will be recording the presentations, but not the discussion. So do feel free to share and discuss openly. So we will stop after the presentations. So this event, it ends our 2025 campaign for 100% open access, which we've been running on social media. But I'd also like to point out that today is also about open science more broadly. So how the ERA Act can support driving open science and implementing that more effectively. Today it also really demonstrates the strong partnership between IFLA, LIBER and SPARC Europe as we build on our copyright reform work to support research and education. And that's part of our years of work on the KR21 programme, which has generously been supported by the Arcadia Fund. And as you know, SPARC Europe has been striving to make open the default for some years now. And we're seeing good progress, but it's far from even across Europe. So there's still a lot to be done. And we see that the ERA Act is a real opportunity to resolve some of the technical, organizational, and financial barriers to open science as a regulatory framework is developed to support the European research area through the ERA Act. And with universities, libraries, and their staff as one of the most important beneficiaries. And I think most of you come from those stakeholder groups today. Now, what you're going to get out of this event, we hope that we can provide the policy context, some background for you, and it's an opportunity for us to have influence on this important legislation through the upcoming ERA Act. So we will be sharing how our three organizations are thinking about how we see what needs to change still. So with the intention of providing you with a common direction for your response to the ERA Act, particularly related to the free circulation of scientific knowledge, which is one part of that consultation. And we're also really keen to hear also from you on what else needs to be considered to help reach 100% OA. And above all, we'd really like to have examples from you, evidence to demonstrate the barriers we're up against. So that's really important for this consultation. So if you are at a university, a research performing organization, any other stakeholder, we'd really like to hear from you. We will be opening the mics later, and we'd like you to share things in the chat. And that can also help us and help you with our response for the consultation in January. So let me take you to the agenda so that you know where you are today. So I will be welcoming Stephen Wyber shortly, who will be giving us that policy context of the ERA Act from IFLA. And then we'll be zoning in on the key areas where EU level action is needed to support open science, including 100% open access, firstly by Eva Melinščak Zlodi from SPARC Europe, and then by Alex Fenlon from LIBER. We've then got some time for questions for any of the speakers, and then we will have a panel discussion. So I think I'm now going to pass on to Stephen, who is far away, and we will be managing his slides, but I think we can hear him all right. So before we get moving, for those of you who don't know Stephen is leading policy and advocacy work at IFLA, with a particular focus on copyright, access to information, freedom of expression, and digital issues. He has strong experience and understanding of working with governments and international institutions, enjoys the fast pace of an international NGO, that's certainly true, and has a passion for finding the key insights or solutions to a problem. And he's also the KR21 program lead. So over to you, Stephen. Thank you very much.
Thank you very much. That definitely sounds like an AI enhanced bio of me. So I appreciate it. So I'm very grateful to Eva for sharing my slides. I'm having to join this on my phone right now. So what I'm going to do in the next 10 minutes is, as the title slide will say, is look a little bit at the policy and political context in which we're looking at the Error Act. So I'm very much going to leave some of the more substantive questions to Alex and Eva, and of course we'll talk about them more together later on. But this is really to give you the background, some of the underlying forces and ideas. So next slide. If you want to turn off for 10 minutes, the key arguments that I want to make, the key things I hope that you'll go away with from this is firstly the sense that so far the way that the EU has legislated for research has not been ideal in any ways. It's looked arguably at the wrong tools, it's over-focused on some, it's not looked enough at others. But we do have an opportunity now with the Error Act to correct this, to really have a research-first policy framework within Europe. However, success is uncertain. It will really depend on you to make sure that open science remains on the agenda and that the steps that are actually taken are helpful. Next slide. So just looking back and trying to understand a little bit about how we've got to where we are now. The first main criticism, and I'll take you to the next slide, is that very much in the EU's legislative solar system, some issues are seen as being higher than others. The way that Brussels works is there are a policy, a regulatory directorates, and there are parts of the EU that just do spending and things like that. So next slide. And it's very much tended to be the fact that it's issues like copyright, like privacy, like data that sit at the center of this legislative solar system, whereas research is very much on the outside. And the consequence of this is that research is treated as a secondary issue, as a bit of a sideshow, a secondary concern when laws are made. Sometimes it isn't even thought about as well, and laws are passed that affect how researchers can access data and information, can use it, can share it, can apply it. And yet their concerns, their needs have not actually been considered in the process. It also means that we end up with a whole range of pieces of legislation that may need to be taken into account when carrying out research, which is hardly a great way of ensuring that researchers can spend their time actually doing research. It can also mean sometimes that there are the logic that might apply in one space applies to research. So a key example is the fact that in copyright, there's a culturally a very strong difference between the commercial and the non-commercial, that you allow for exceptions, you allow for special treatment for non-commercial things, whereas commercial is expected to do things in other ways. But that's not a distinction that is particularly helpful. That's not a distinction that is useful within the research space, arguably, especially given the huge focus that there is on promoting knowledge valorization and partnerships. Next slide. In parallel, we have the issue that the EU, of course, it does research. It does it very much in terms of funding and in terms of soft law. And so, of course, the EU is a very generous, a very significant research funder. But the problem is money doesn't actually solve everything. Money doesn't guarantee that the money can be well spent. Simply spending money means that we may just risk ending up paying more for licensing fees, paying more for clearance, paying more for issues like this. It doesn't allow us to think about how we're spending that money. What is the most efficient, effective way of doing it? And so it doesn't allow us to think about the most efficient, the most effective way of doing this. So ultimately, we end up in this situation where the EU's generosity, the EU's ambition in terms of the amount of money it spends on research is not matched by the regulations that shape how this money is used and how effectively it can actually be used. Next slide. And so I think the argument is that we want to have a sort of Copernican shift, the idea that rather than thinking that the Earth is at the center of the universe, we want to see that the sun, in this case research, is the center of the universe. That should be the center point that guides us in our decision making, that guides us in the preferences and the decisions that are being made. So we need research to be that primary legislative goal. We need to look, therefore, at how can we make sure that other bits of law, both existing ones and incoming ones, are actually supportive. And that when a piece of law stops someone carrying out research, stops the flow of knowledge across borders, that actually, and we need to deal with that. We need to do something about that, not to see it as a cost of doing business or something like that. So that's really the ambition. The next slide. And so this is really what we can hope for with the Error Act. It's this opportunity to do better for Europe, to make sure that if there's a barrier, that's seen as a problem, that's seen as something that we need to be able to remove. Next slide. Now, the really good news in this is that there is some very high level support. I've put these in the wrong order, but I certainly have put them in protocol order. So we have seen Commission President von der Leyen being very open about talking about research as an area where she wants to see progress. And this is heavily linked to her work around the importance of competitiveness, making sure that the EU is coming up with the new ideas, advancing them, turning them into change, turning them into businesses. And so she's been very forward about talking about choosing Europe for science, about having the most attractive, the most interesting environment where for researchers to actually operate. And that, of course, includes the possibility to work at a continental scale alongside things like the protection of research freedom, good research careers and quality of life and things like that. So she has been strong on this. She's been strong about talking about that need for the fifth freedom. Next slide. And similarly, and this obviously comes from 6 months earlier, but we also have the research commissioner, Ekaterina Zaharieva, who's also been clear, and this was in her hearing towards the European Parliament, that her first priority is to strengthen the European research area with an Error Act. And again, underlining that concept of the fifth freedom. So there's clearly a strong political weight behind this, that there's the ideas that are there. And of course, the challenge is, and this is not the only time that this happens potentially with this commission, is that there's a temptation to pick a good name, to pick a good title for legislation, and only subsequently to look at what might actually go in it. But certainly enough work has happened up to now. So if we go to the next slide, you have a bit of a timeline that shows how we get there. So arguably some of the work around this started ages ago. It started in 2021 when the European Research Area Policy Agenda was designed, and there was already work in there about how to support access to publicly funded research and research in general. So already back in spring of last year, there was a major report. In May, Enrico Letta called for this fifth freedom. This is the first of 5 major recommendations he made. Already in the autumn, once the new commission was starting to take shape, this was up there as a priority, that there was this push on this fifth freedom, this push on the Error Act. Now, admittedly, then it had a few months where it was maybe less of a priority, given that the real push was on startups and scale-ups. But it's really come back from July. Things have got really intense, and they will continue to be intense. And I'll show you another timeline later showing where we're going on this. Next slide. As said, it's a commission that tends to it picks up a good title, and then we think afterwards about what might be in it. But certainly some things, some hints of what might be in there that have been there, especially since Commissioner Zaharieva's hearing. There's a lot of interest in doing something with freedom of scientific research. This has been a priority for some time, and certainly with what's going on in the US has only become more high profile as a topic. There was a big interest in mobility of researchers, looking at career structures. Sorry, I apologize, there's an announcement going on behind me, but mobility of researchers, career structures, looking at how to make it easier to do visas, how to make sure that it's easier to travel from one social security system to the other, looking at career frameworks, so experience is better recognized from one country to the next, looking at questions around access to research infrastructures, and typically this can include archives, this can include collections. Libraries aren't yet seen as research infrastructures, but arguably they should be. It'll look at questions on research security, obviously another hot topic right now, the coordination of research programming. There's a strong desire to get to 3% of GDP being spent on research. And then questions around equity, around making sure that there are no longer the barriers to women in research are removed, and that there's really a truly equal opportunity to advance in careers and realise potential. And of course, there is open science. This does get in there, but as we'll come on to, we shouldn't see it as a given as yet. The next slide. So we're at the stage where there's a clear political commitment. There's a good body of evidence out there. There is arguably momentum, but as I said, it's not guaranteed that we're going to get to something that the sort of thing that we want. So the first challenge, and let's go to the next slide, is it's around maintaining focus. And I think you'll already have seen from that list of topics that this is potentially quite a broad area of work. And this is for a Directorate General that doesn't often do legislation per se. So there's a level of ambition in here, which we certainly support, but which we have to recognise is, by its nature, ambitious. And it's also an area where we need to be careful to pick what are the areas, what are the topics that actually require legislation. Given that everyone is so used to working with soft law, working with funding, temptation to think that we can do things through law is quite high. The challenge, in addition to that, is not only about subsidiarity concerns, but also about touching on topics, on policy areas that are run by other parts of the Commission and whose support will actually be needed. So firstly, it's that maintaining focus, that looking hard, that reflecting hard on what is it that we actually need to do? What are the mistakes, the errors in existing legislation that we need to correct? What are the targeted interventions that we can make that will support the drive to 100% open science and open access and open science in general? Next slide. Touching on this, there is the question of competence issues. I already alluded to the fact that there are the topics that are likely to be included, that we hope will be included in the Error Act, are also dealt with by other parts of the Commission, the most obvious being copyright. And so, for example, if the Error Act is to include a secondary publication right that's treated as being part of copyright law, if it is to include a reform to research exceptions to make them better suited to the way that research is done today, this will require coordination, this will require cooperation from the copyright unit. And it's not a given that they will let this happen. It's not a given that the Commission will have the political capital necessary to do this. Now, once again, we fully support, I think, the whole point of having an act that's focused on research is that decisions are made in terms of how well they support research, how effective they are in enabling European research. The minute that we move these discussions into another space, into copyright space, the social security space, whatever other space, we lose that focus and we lose that opportunity to pass laws that are optimal for the sector. So obviously we will have a huge support for research leading here, but we do have to bear in mind that there's a risk of other parts of the Commission saying, well, no, this is actually ours. Similarly with member states, the reason why we talk about freedom of scientific research is because education is a national competence, not an EU competence. And so there's this really clear sense, this really clear worry that if we talk about research, then member states will say, no, that's not yours. So we need to be careful about this, to pick those areas that really do need, that really will benefit from European level action. Next slide. The final major potential barrier is the stickiness of the status quo. We know that there are actors who quite like the way that things work right now, either because they don't want to have to change, they don't want to have to be told to do something that will support open science or that will support wider European goals. And sometimes, of course, this makes sense. It's important to defend institutional autonomy. But we also see in the consultation responses from major publishers that, as far as they're concerned, the current system that allows them to make large amounts of money, that allows them to run schemes and to position themselves as being entirely central to the research infrastructure, that obviously works for them. They don't want to see it change. Obviously, that's not an opinion that's going to be shared across the research sector. We know from the Policy Action 2 report that that's definitely not the case. But nonetheless, there is going to be that resistance, and we have to be aware that some will oppose efforts to update copyright law, to modernize it, to make it better suited to the way that research is done today. Next slide. So just in terms of looking at what now, what's the space we're entering into with the points that Eva and that Alex will talk about. Next slide. So you've got another timeline up on the screen, I hope now. I think Vanessa's already talked about the questionnaire that's out right now with the deadline of the 23rd of January. That's an opportunity to say we do need to do something about open science. We do need to look at knowledge flows. The status quo is not good enough. It's not just that we need to have a couple of lessons because we're not smart enough to use the system as it is right now. So we need to go further than that. But there are other angles. There's already some work starting on a parliamentary motion for resolution, which will be quite high level, but it's an opportunity for the European Parliament to set out some issues, to set out where it wants to go. There's an economic study into the impacts of implementing a secondary publication right, of reform to copyright. There's a potential for an own initiative report in the Parliament to go into more depth about these things. There'll need to be a full impact assessment of the different aspects, the different ideas included in what will eventually be in the Act. And then around September, we expect the Act itself to be published. So we've got another 9 months to sort of shape things, to bring that experience, those stories, those examples to bear. And then once it's out, the shared focus will have to shift to the Parliament, to the Council, to Member States, in order to make sure that we can build on whatever basis the Commission originally gives us. Next slide. And this is the final one I'll talk to. And this is just echoing very much what Vanessa said at the beginning, that we can't expect anyone else necessarily to focus on this. And I think in particular, while of course there is a strong open science sector within Brussels, at the same time we do have the discussions about the Framework Programme 10, about Horizon Europe taking place. They will attract most of the attention for obvious reasons, and it is a big deal. And so we do need to be ready to play a leading role. We do need, as the specialists in information and knowledge, to be ready to lead the charge. We will find support. I wouldn't be worried about that. But I think we need to be ready to be the ones who shout, who say, no, we can't have a credible European Research Area Act. We can't credibly say we are supporting the fifth freedom unless we actually take action around open science, around copyright, around the laws around information. So I think I'll stop there because I think I've already gone slightly over the time I was supposed to have.
Thank you very much indeed, Stephen. So thank you for reminding us that we really need to do better. It's an opportunity to do better for research and to remove some of those barriers, to move away from the stickiness of the current status quo. I really liked point. And thank you so much for showing the political commitment to this and taking us through the process. So if there are any clarification questions, please do put them in the chat. And otherwise, Stephen will be with us for the discussion later. So do add your things in the chat for Stephen. I'd now like to introduce Eva Melinščak Zlodi. She is a scholarly communication and e-resources librarian at the University of Zagreb at the Faculty of Humanities and Social Sciences. And she's responsible for institutional repository development, support in electronic publishing, providing electronic resources, information literacy, education, and bibliometric monitoring at Research Output. She currently chairs the board of SPARC Europe, so a special welcome. And she's also the national coordinator of Croatia in the KR21 program. So over to you, and thank you for sharing our views on this, Eva. Thank you.
Thank you, Vanessa, for the introduction, and thanks very much to Stephen for setting the scene and making it easier to continue talking about this. And thank you all for coming at today's event. And my role, as Vanessa said, is to present you the position of SPARC Europe, related to this ERA Act and the priorities that we want to have included in the ERA Act. And I have to say that, as always, SPARC Europe is an organization who advocates for everything open, but also collaborates and tries to collaborate as much as possible. So this position is developed in collaboration with LIBER and with IFLA, and we hope to continue collaborating with everyone interested in pushing this further and also hearing you at this event, so helping us to refine the position. We will share the position with everyone here, and I have just picked some of the elements of the position that will be stressed today. We will not have time to go through everything that's important, but I would like to say that some of the elements, and this was already stressed by Stephen, that need to find their way in the ERA Act is open science, rights, infrastructures, and one thing that is important for everything and lies beneath everything is equity. So how do we deal with that? And Vanessa mentioned we shared the link to the questionnaire. You will have an opportunity to respond to the questionnaire and try to bear in mind all the things that we will stress as important here. It is true that sometimes they might fall out of the scope of what is strictly what could strictly be managed by a law, but still this is the time where we can also provide input in a narrative form and explain what is important for us and where are the key barriers and how they could be overcome. So why is this important now? One of the first questions in this questionnaire is whether you find a current level of open access and open science sufficient. And this is actually a very hard question to answer because there is a lot of effort and a lot of successes by many of you and by many of us. But still, when you look, it's far from 100% open access, and it's also very much uneven. So we can be very pleased with what we've done, but we cannot be satisfied by the current situation. So this situation is very uneven across Europe, across member states, across different types and different small or large institutions, across scientific disciplines especially. And there are different causes for this unevenness: economic constraints, publishing cultures, historical context, also weak or sometimes absent policy incentives. And there we come with what Stephen described as very fragmented European research ecosystem. My presentation will be not as nearly interesting as Stephen, so I will only have text, no Beatles pictures, but please bear with this. So we definitely need for more European political and legislative alignment, and in order to reduce some of the barriers, economic, organizational, and at this point, very importantly, the legislative barriers, and to enable a more coherent and equitable open science landscape, also to enable collaboration that was mentioned, cross-border collaboration, cross-sectorial collaboration, and to call for alignment in rewarding open science practices, but also requiring them. And when we speak of open science, we need to take the full spectrum of all the activities and processes, so as defined in UNESCO, and we have to preserve this slogan of as open as possible, as closed as necessary, because in today's context, very often you can observe some kind of shift in narrative to as open as necessary and as closed as possible, which is a danger. And we have to try to stress why this is harmful. We also need to stress the importance of currently unsustainable open access economics, because this is largely, when we see the high shares of open access, this is often achieved at high costs through a high share of open access paid models, APCs, BPCs, new development charges, publish and read agreements. And some of these models, or maybe all of them, are unsustainable even for well-resourced systems, institutions, countries, or disciplines. And they are very often inequitable and exclusionary for many institutions, and especially for unaffiliated researchers. This, of course, present a barrier to participation, and they slow collaboration and innovation. So this is a definite important barrier. We need more transparency also in this arena of publishing contracting deals. So full transparency of publish and read agreement, which is essential for public accountability and for cost control. And we need to move in line with also Council conclusions from 2023. We need to move towards more equitable open access models, like recognizing the role of diamond open access, the role of trusted and publicly governed open repositories, the new publish, review, curate models and platforms, the role of preprints. But also in all this, we need to ensure that there is a high quality standards recognized and adhered to across these all models. And then we come to the area which is very much at heart of what could be legislated. So not just a goal, but something that is very much an area appropriate for legislative strengthening. And this is the area of repository deposits. So we need to make our authors and institutions able to deposit the outcomes of research work into open repositories under no additional cost and without an embargo. And this can be achieved either through a European-wide secondary publishing right, which is unwaivable, so not able to be overridden by publishing contracts, or also through strengthening institutional right retention policies. So this is something that we are calling for very strongly in this future act. And also one thing related to this is more consistent use of open licenses and more legal clarity, which will be achieved through that. And the responsibility for open licensing is, of course, on the authors, but it also has to be supported and strengthened and reinforced by funders and by the employers or research performing organizations for these authors. So we need more clarity and harmonization, also not just on publication rights, but also for the research data. And our institutions need more support and more legal capacity to deal with all these issues related to rights. And then when we speak about the data and the rights to data, we also need to acknowledge that there are gaps in knowledge about fair data across Europe. So we currently don't even know about enough about the uptake and the existence of fair data, how it is produced, where and under which conditions. So we need to have more research data set catalogs, more reliable and more granular metadata appropriate for every discipline, and fair compliance, which is not limited to just certain fields and certain institutions or countries. And when we speak about metadata and the knowledge and capacity, then we come to open infrastructure. So we want our research, European research, to be relying on open infrastructures, systems, and services and to reduce the solely reliance on proprietary and closed and non-interoperable systems. And this goes not just for infrastructures and services, but also for research information as it is defined by Barcelona Declaration. So we need our institutions to reclaim ownership and control over research information, including bibliographic metadata, including abstracts and reference lists. Definitely, information on all the software data, instruments, or anything else that is included in the research lifecycle, also about funding and contributing information. And ideally, this information should be openly reusable whenever this is ethically and legally possible as an open domain data. And this should also enable strengthening research assessment reform, which is another key issues in bringing reform to this area. We need to move beyond publish and perish principle and to reduce dependence of specific venues that are commercial and that are quantitative. We need to recognize diverse contributions of our researchers, teachers, and all other stakeholders, recognize diverse career paths, and support reform movement. So this is something that will also give a specific strength to our moves. And then our systems that will enable all this will need to rely on robust monitoring processes and also persistent identifiers that will be included in those monitoring systems. So our institutions need to be able to monitor open science practices, their impacts and their costs, and this should be in line with OSMI principles. And just a final conclusion, this is a very important time. This is a very important opportunity, ERA Act, to enable and strengthen openness, equity, and resilience of our ecosystem. And the key points where we see that this could happen is alignment, right management, sustainable open access models, open infrastructure, responsible assessment, and robust monitoring. And this is where I will conclude and where LIBER will continue with our mission. So thank you for the attention. And this is where I stop sharing my screen. Yeah.
Thank you so very much, Eva. So we really have quite a lot still to do. And there are, as I said, some opportunities. How can we make OA more sustainable, more transparent? How can we move to more equitable models? How can we ensure that European SPR comes into force and where also rights retention policies are encouraged and where open licensing and fair and open infrastructure is really duly supported, also for a healthier research assessment reform system. So thank you so much for that. So it's now my pleasure to introduce you to Alex Fenlon. He's the head of copyright and licensing at the University of Birmingham. And at LIBER Europe, he is the co-chair of the LIBER Copyright and Legal Matters Working Group, which works to enhance the awareness of legal issues across European research libraries. He's also a member of LIBER's AI task force, and that's one of the themes also of the ERA Act, by the way. Alex has worked in intellectual property for over 20 years and has been at the university since 2014, and his role includes advising the university education and research communities to ensure that copyright is not a barrier to teaching or research activity. Good luck with that one. Okay, thank you. Over to you, Alex.
Thanks, Vanessa. Thanks, Aoife, Stephen, and thanks everybody for attending. Hopefully you can see my slides and you can't see my presenter view. Is that right?
Yes.
Perfect. I've done that right. Amazing. Thank you. Okay, so I'm just going to start off with a super quick overview for colleagues of who LIBER are. So we are an organization, a membership organization of over 420 research libraries from across Europe, and we have one mission, and that is to support and enable world-class research and to provide and share knowledge and support our member organizations to deliver real world impact. In terms of the copyright legal matters working group that I co-chair with Judith Ludwig from TIB in Germany, we're a group of librarians and information professionals, lawyers and professors that really work with the legal issues that impact on research libraries. We share news, updates, policy practice, advice on those issues that affect our members and their colleagues that they work with on a day-to-day basis. We monitor and engage in those legislative developments and really try and support our member organizations and our institutions to really work with the legal framework or to engage in advocacy to try and shape that legal framework that enables a research activity to take place. In terms of the role of the library, the mission of the libraries align really closely with the objectives of the ERA Act to enhance research activity and enable access and the reuse of research outputs. We actively support open science initiatives, ensuring compliance with open access requirements, making sure research is findable, accessible, interoperable, and reusable, via research data management systems, via our research infrastructures. And libraries have been at the forefront of exploring how we can provide access to publicly funded research in a more equitable manner so that the public can benefit from the activity that they fund and leading to that real world impact. We work with educators, researchers, students. We see the challenges posed by copyright law and licensing practices on a daily basis. We work with these frameworks that govern our access to content for education and research purposes and really understand the complexity of the issues as they impact on those on the ground and those stakeholders developing those policies. And our teams really play a vital role in the education and training of researchers, helping the next generation of researchers acquire knowledge, develop and leverage their skills. And whether this is through research methodologies, understanding publishing pathways, or providing literacy skills, whether that's in relation to information literacy, digital literacy, AI literacy, copyright literacy, so that researchers can really find and use that knowledge. And we really are, I think, as Stephen said earlier on, we really are a vital part of that research ecosystem and research infrastructure. Coming back then to open science and really focusing on this well-known UNESCO recommendation from a few years ago, which is widely known and widely endorsed. And we know that open science is a major policy driver for funders and stakeholders alike to enhance the visibility, engagement, and trust in science and research. We know that it fosters and enables partnerships between research organizations and the public through citizen science activities or in collaboration with public sector or industrial partners. And there's a significant investment to enhance the discoverability, accessibility, usability of research outputs. We've got the European Open Science Cloud, EOSC, and the infrastructure that demonstrates how investment is used to enhance openness and collaboration. And this provides the repositories, the tools, the platforms for data sharing with common standards that ensure reproducibility, validity, and robustness. And libraries are at the heart of many of these key policy drivers, and we are key to delivering the support to and access to knowledge. And through that work, and through our support of the researchers and educators, we can see the impact that copyright has on digital and data legislation. There are 6, 7, 8, 10 different parts of the EU regulatory framework, whether they are directives or regulations, and we really see how that impacts on the activity of our librarians, of our research support professionals, and the researchers themselves. And we really know that they need to develop their legal literacy skills to understand and navigate a cornucopia of laws. Laws that, as Stephen said, are often created in isolation without considering their impact on the research sector or how they might interact with other bits of existing legislation. I really like the report, the Commission's report, improving access to reuse of research results, publications, and data for scientific purposes from back in 2024. That extremely weighty report found that 80% of researchers still report problems accessing content for their and data for their research. This is despite a number of years, decades of open access, of open science directives, of the open movements, of mandates and policies. There are still challenges with the copyright framework, despite modernization in 2019, not 2029. That's looking a bit too far down the path, perhaps. And with the introduction of the copyright in the digital single market directive in 2019 and the AI Act more recently. And what you've got is still fundamental issues remain that frustrate this idea of a truly single European market. The reality is that there is uncertainty and risk that limits innovation and the creation of partnerships to enable the impact of research to be realized. We have all of these translational pathways, knowledge exchange frameworks designed to really leverage public investment, to launch spin-outs and startups, to work with industrial and community cultural partners. But without a holistic approach and a sound regulatory framework, opportunities are potentially lost. And I think, as colleagues have said, there is that real need to truly harmonize the legal framework across member states to enable the vision to be fulfilled. And the ERA Act is an opportunity to enable this, or to begin the process to do so. We need a simplified legislation that is the same in Italy, Denmark, Greece, legislation that is without national nuance, that enables research to take place collaboratively and openly across the EU. And let's look at a couple of examples where the ERA Act could help. The EU law, current EU law, has a copyright exception for research, which comes from the InfoSoc directive back in 2001. And that contained a requirement to introduce an exception or limitation for use for the sole purpose of illustration for teaching or scientific research. It's an optional exception which gives member states some freedom to decide how and when they implement it. Some follow the text of the directives, others take their own different approach and add their own nuance to it. The non-commercial nature of the exception is also challenging, as research institutions and researchers are increasingly obliged to deliver real-world benefits that include societal and cultural benefits, as well as commercial benefits. There are numerous schemes to foster and encourage public and private partnerships, yet limitations like this pose problems. The result of the different interpretations at national level and different applications across those national boundaries, where one researcher might benefit from the exception in one form, yet their collaborator a few miles across a border might have a different interpretation, or at least they might not have it at all. And the ERA Act could really provide an opportunity to refine or align some of the wording, or offer a new exception that can really harmonize and simplify some of that legislation to really enable collaboration and reframe the restrictions on non-commercial and or the nature of the exception itself, as an example. If we look at another example, another high-profile example currently in focus at the moment, we look at the text and data miner exception as introduced as covered by Articles 3 and Article 4 in the DSM directive from 2019. TDM activities, as we know, are increasingly reliant on digital tools to aid research methodologies, unlocking new knowledge faster and at greater scale than ever before. And it certainly is revolutionizing research and scientific discovery in all fields. Yet, as with the research exception, a lack of consistent standardized language across the implementation of this exception prevents researchers from working collaboratively with each other or with scientists in hospitals or in industry, for example. The exception is silent on key parts that are essential for collaboration, data sharing within research groups that span different public institutions, for example. We also see issues with licenses for electronic content, which, despite the exception expressly preventing contracts from limiting TDM activity, actively try to do just that. We see licenses that place additional administrative burden on researchers just to exercise their ability to use the law. And again, this is magnified when working collaboratively across international borders. The EU, the ERA Act might be used to remedy some of these challenges by offering a consistency in approach, perhaps reinforcing and enhancing legislation to reflect the practice on the ground, unburdening researchers and potentially unblocking their path. IFLA mentioned secondary publishing rights, and those are the rights that grant authors the ability to publish their work in addition to the primary publication in their venue of choice. These rights widen the availability and visibility of research publications by making them accessible to the public. Initiatives like Coalition S and Plan S and research funding organizations have been promoting and mandating for the open release of research outputs for many years. And while there has been huge progress, the flip to open is still challenging. SPRs try to accelerate this openness using laws that enable researchers to release their works. These do not rely on funder mandates, institutional or publisher policy. It's the law. And this, for me, is the next stage in open access and open science, taking institutional and funder policies and embedding them into law that guarantee the public availability of research outputs for everybody. And it's a core part of the fifth freedom, the freedom of research, innovation, knowledge, and education from the letter report in 2019 that Stephen mentioned. And a central element of Draghi's vision for research and innovation being a fundamental goal of European collaboration. If we look more closely and quickly just at SPRs that exist across several European countries, you can see from the slide that there are differences in national implementations. Each country has chosen their own approach, and each is slightly different in terms of the requirements for public funding, embargo periods, which versions can be made open, and what uses are permitted. And so far, so familiar. With an EU-wide SPR, there is an opportunity to support open science and really foster the growth by making research outputs available by law in a way that avoids some of the challenges that we've seen in other aspects of the law in the previous two examples. And ERA is a really great opportunity to try and do this. It's a real exciting opportunity to make our voices heard. And we need, as library communities, library professionals supporting our researchers, we need to engage directly with that consultation process to help shape the ERA Act in a way that it supports us to deliver world-class, impactful research to change people's lives. And ERA provides the chance to equalize, to harmonize research regulations across the EU, to create a governance framework that is universally and equally applied in all member states to promote the benefits of European research. But this can't be done in isolation. It needs to look across the European legal landscape, regulatory landscape, and considered holistically. It must look at those existing frameworks, adjusting digital data and copyright legislation, and make changes to simplify and remove some of the complexity and blockers. And now is the time to act, to influence the development of the ERA Act, and to work to make the ERA Act a catalyst for collaborative research, creating and sharing knowledge openly that empowers every researcher in every research institution across Europe. Thank you, and I'll stop sharing.
Thank you ever so much, Alex. So thank you for reminding us of the importance of the Copyright and Legal Matters Working Group at LIBER. and also talking about that patchwork of disharmony that you talked about, and the need to simplify supportive legislation. And it was really helpful as you went in to look at the research exceptions and the TDM exception, as well as honing in on SPR. So we've covered a lot. We are collaborating with LIBER and with IFLA to put all of those arguments together in one place for you, which we'll be sharing after the holidays, so that you can use that input, particularly for the section on 3.2.2, which is the more free circulation of knowledge, right? So those arguments will help you also going forward. Thank you so much.